Sorry, had a little unmuting trouble. Welcome everybody. Thank you all for hanging in for the entire ESELA series. We are ending today with conflict management because honestly, this is the time of year where we see a lot of conflict. We are certainly starting to see a big uptick in our practice over the last week or so as we sort of approach spring and the end of the year. And that means you all are probably seeing that as well. So as Kim said, my name is Erin Heydrich. I'm here today with my colleague Claire Parsons. We are attorneys in Bricker Graydon's education practice group. We focus primarily on special ed and other student services issues. Our colleague Laura Anthony was supposed to be here with you all today, but unfortunately she experienced a death in her family. So we are stepping in to fill in her shoes. And if you have ever had the benefit of seeing Laura present, you know that we have big shoes to fill. So we will do our very best. If you have attended one of Laura's presentations before, you will probably know that she often likes to end her presentations with a themed poem. So fear not, I do have Laura's poem and I will be sharing that with you at the end of today's presentation. Because we are stepping in at kind of the last minute here, we've had to make some changes to the order of our presentation today. So Claire is going to start by talking to you about the formal procedures for resolving conflicts, such as due process hearings. Then we'll plan to take a break after Claire's portion of the presentation so everybody can refill their coffee. And then I will talk with you about ideally how to avoid ending up in the formal conflict resolution process, if at all possible. Spoiler alert, it is not always possible, but we will present some helpful tips to avoid it, hopefully. So I will discuss the top 10 special ed issues that we see creating conflict and some strategies for resolving those conflicts. There is a lot of great content in this ESELA series, but I tend to think this session on conflict management is in some ways the most useful. At Bricker Graydon, we have a team of 30 education professionals who work full-time with schools across the state of Ohio. And that should tell you something because school districts don't call lawyers when everything's going great. We need 30 people because there's a lot of conflict. I don't have children of my own, but I have children in my life that I love. And when I think about how hard I would fight for those children, the answer is pretty dang hard. And if you have kids of your own or have kids that you love, I'm sure that you would give the exact same answer. So the conflict that we're dealing with in special education isn't your garden variety conflict over a business transaction. It's about people's kids. Special education conflicts are also a special kind of conflict because of you all, the education professionals. My guess is you did not get into this job for the fame and fortune. You probably got into this line of work because you want to help kids. And so to borrow from everyone's favorite TV show, The Bachelor, you are here for the right reasons. You have trained for years to do what you do, you're good at it. So when you are challenged by a parent or told you're not doing a good job by a parent, that disagreement can feel very personal, understandably. So I know you all are dealing with these very high conflict, highly emotional situations day in and day out. I hope by the end of today, we will have given you some strategies to make that part of your job a bit more manageable. And so with that, I'm going to turn it over to Claire to talk about formal conflict resolution strategies.
All right, good morning, everybody. I know that on a Friday morning, on the first day of March, the first thing you guys want to talk about is formal complaints and litigation. That's my attempt at a mediocre joke, so I apologize for that. But I am very new to Bricker Graydon. I've only been here about a month. You may have seen me at some of the other ESELA series earlier this year with Laura. But I am not new to special education. I have done special education for the vast majority of my practice, and I got pulled into it very early on in my practice and frankly just had to learn it, and I did. So I have done numerous due process hearings and managed many other due process proceedings. My goal with all of them is to try to resolve them, but unfortunately, resolution is a two-way street. And so I didn't always have that ability, but I did develop an understanding of the process. And one thing that I kind of want you to understand is by learning about these processes and how they work and what all the steps are, I hope that you have a respect for litigation and an understanding of the risks involved and the time and the drama involved, to be frank. But I also hope that you're not so afraid of it that you can't stand up and do the right thing for students, because there are many ways to mitigate and address risk in the process. And having capable counsel who understands the process can really help. So that's kind of the goal today. If you do have questions, I think Erin and I and Kristen will probably be checking the chat. So feel free to chime in. But right now we're going to just kind of talk about the processes. So the first thing, and just so you know, I am starting at section 6 in the written materials if you are following along. I'm not sure exactly on the page number. I think it's around 17 or 20 or something on yours. So
it's
just
the top of page 17 in their handout.
Thanks, Kristen. So 17, if in section 6, conflict resolution options and strategies is where I am starting. So we're going to get to due process, but as you probably know, there are also other complaint processes other than due process where you go to a full hearing. And the first one is the administrative complaint. And as you know, there are administrative complaints that can be asserted at the federal level, but more commonly, I see them filed at the state level. So administrative complaints are a little bit different from due process complaints because you don't go to a formal hearing. Instead, usually what happens is there is an investigation that occurs where somebody through a DEW is assigned to handle the matter, and they look into it. And so usually what happens is you get a complaint and a notice from DEW that identifies the issues to be investigated and requests information, and then gives the district an opportunity to respond in writing. And we're going to talk about some of the details there. But the timeline for these investigations is 60 days. That can be extended, but you don't necessarily have a guarantee that it will. And then you also get an opportunity to respond in writing, and generally there will be a request for records, and sometimes those can be pretty copious. One thing to note about this complaint process versus due process complaints is that anyone can file a complaint with DEW. It does not have to be a parent. It can be a staff member who may be disgruntled, or maybe just a concerned staff member. It does not have to be someone with standing to assert claims on behalf of an individual student. So that is something that is critical. A complaint will be filed, and then the investigator is assigned. And then what you'll get is a letter of allegations that follows, usually a week to 2 after. And then they will review and identify the issues and send that to the district. So the document request is usually a very short turnaround. So it's just a reminder to have files in good order so that they can be, potentially submitted to counsel if you're involving counsel for assistance, and then submitted to DEW for their review. Now, mediation is offered, and it is a good option to consider. But it may not be effective in every case. Sometimes you may want to consider it to build a relationship with the other party or fully understand what their concerns are. Sometimes you may want to consider it if you think you can actually get it resolved. I generally say consider mediation anytime you can, but just know that in the administrative complaint process, it can be a little bit more difficult to get things mediated than in due process, because you may not really know as much about what is going on. And you may have to do a little bit more heavy lifting in terms of creativity and coming up with solutions on your own than you might in the due process proceeding, because in due process, it tends to be a little bit more focused about what a party wants. Now, when you are responding to these complaints, it's not something where DEW asks for a narrative explanation every time. They may ask for a response to particular allegations, and they will ask for a record because it is investigation. But I think it is a good advocacy point to present your side of the story and your narrative explanation. You should be cautious about the way that you do this, that you don't go into stuff that's not raised, and that you don't volunteer stuff that's not really an issue, And also that you don't make the allegations in the complaint look better than they actually are. Sometimes when you are getting these kind of complaints, it is less likely that the parents or the people may not be represented. And so they may be a lay person creating this. And so you don't want to talk up their allegations in refuting them. I've been challenged with that when I'm dealing with unrepresented parties. But you do want to provide a narrative. It's a good idea to at least take the opportunity to provide your side of the story so that at least DEW has some context to consider when they're completing their investigation. Then what happens is there's a letter of findings, actually I skipped something. So in your response, you can also talk about corrective action that you've already taken, and it's often a good idea to consider whether there has been a mistake or an error or something that fell through the cracks, and whether you can try to fix it and address it proactively. That's generally not a bad thing in special ed. In other areas of the law, that can kind of work against you as an admission, but in general, in special ed, I find that the proactive solutions are good because I think it builds credibility with the parents that at least you're focused on the interest of the student and trying to make things right. And it helps mitigate any risk of corrective action or compensatory education if you do end up getting into due process later on. So if you get into the point where the investigation is not resolved, you will ultimately get a letter of findings, and OEC will determine whether you have complied with applicable laws, regulations, and it'll notify the parties in writing of the findings. That'll include some factual findings, and then that'll include some legal conclusion findings. And then usually what happens if there is a finding of non-compliance, there will be an order of corrective action that the district will have to figure out how to implement and address, whether in the IEP or otherwise. Now, if needed, DEW may offer to provide technical assistance or negotiations to implement this corrective action. So a few things that I may have already gotten to, but I want to just make sure I cover. So in responding to the complaint, a couple procedural steps that you can take to make this process just a little easier. You want to review the original complaint and the letter of allegations. So if you are doing, if the investigation is being conducted by DEW, you may have to request the original complaint, but you should get it, because sometimes the allegation, the letter of allegations, anytime anyone characterizes or summarizes a document, it's possible that they miss something, or it's possible that they're looking at it from the lens of their investigation and they overlook a statement or a comment that might be relevant to the defense or the explanation that you want to offer. So it's really a good idea to get, straight from the horse's mouth, the complaint from the party who asserted it. You should evaluate, and I'm going to say non-judgmentally evaluate procedural compliance, without attacking anyone or without looking for somebody messing up. Did we do the right thing? And so look at that. And if we do need to self-correct, it's a good idea to do it. I really do believe in a stitch in time saves nine when it comes to this stuff. So look at whether we did the right thing. And if we didn't, what is the possible self-corrective action we can suggest or implement? Consider mediation. I really do believe that in special education, relationships are everything. And generally what I find is these complaints and these due process hearings come down to the relationships breaking down. And that can be for a variety of reasons. And I'm not always suggesting that that is the result of actions on the school officials. That isn't always the case. But mediation is not just a way to avoid litigation. It can be, when done right, a way to hear and listen and understand the other side and repair a relationship that got damaged. Because the one thing about special education litigation that is particularly hard, and I've done litigation in other contexts, if you have a car accident case and you try to settle a car accident case, one side pays the other side money and then they walk away and they never have to see each other again. But with special education cases, you have to maintain a relationship in many cases for a decade or more, after you've gone through litigation. That can be really hard. So when you can get a chance to repair that relationship before fighting it out, it's really a great option. You can request an extension of time if necessary. Now, sometimes I find administratively, this depends on your investigator and whether your investigator is super busy or looking at email and things like that. But it can be a good idea to request it if you need it. And I generally think, making sure you've got the time to do what you need to do is important. So go ahead and make that request and don't wait until the last minute, because for planning purposes, that might make it difficult. And you want to collect all the documents regarding the student for the time period in question, and identify everything requested by the agency. So there is sometimes a judgment call you got to make when you get a request for documents from the agency and maybe you have additional things that are relevant. Now, if you're presenting the additional things that are relevant, you do want them to be relevant and you do want them generally to be helpful to you. So just be cautious that you're not adding other things that may kind of expand the scope of the investigation. But you do have the ability in your narrative explanation to offer some more documents if they are responsive, relevant, and supportive to you. And then we talked about preparing a narrative response. And I generally think, like, there's no requirement to do this, but lawyers do this for a practical reason. We do like citations to the record, which is the record. The record is the documents we provided in the investigation. And we do those direct citations to page numbers. We'll often Bates label at the bottom each page so people can find what we're looking at. And the real reason you want to do that, it is time consuming and it is complicated, but the real reason is that you want it to be like the person is sitting next to you with the file and you're walking them through it, okay? And you want their eyes to be where your eyes are in looking at and understanding these documents. If they go off on their own, it's very possible they'll miss what you're seeing. Some of these documents can be kind of small and then they have various portions and content to them. So using those citations, it's a small step, but it's something that can help the other side see it, the investigator see it your way. And if there is an on-site investigation, it's good to have the documentation necessary available in case any witnesses need to refer to it in answering any questions. So this whole review has to be done in 60 days, but there can be an extension of time, and the district's opportunity to respond is usually happens in the course of that. So one thing to be aware of, so we're talking about due process next. So you may wonder, like, what happens if there's an administrative complaint and a due process complaint at the same time? And I have had this actually happen a lot. And what I tend to find in many cases is that the administrative complaint is kind of a lot easier for parents to just fire off. So I have had some where they file the administrative complaint and then they immediately find a lawyer and they file a due process complaint and we get them both at the same time. And sometimes I'll get the administrative complaint after. But the process is kind of set up that if there is a due process proceeding, DEW may set aside that part and just say, let that be addressed in due process. It's a little bit more complicated and it is individualized. Now, that's not an option for all issues. Now, as I said before, people who, are not necessarily the parents of a student can file a complaint with DEW. So it may not always be something to raise, but sometimes I do let the agency know that, that there is a due process proceeding filed, and just letting them know that may resolve it. So statute of limitations is a little bit different than with due process, and we'll talk about that next. But for administrative complaints, the agency is usually looking at something that happened no more than a year prior to the receipt of the complaint. And so, that's something potentially to raise with them or to raise in your response, so that they understand that things are kind of beyond the scope. And that is that is included in the regulations as well. So there is there can be an appeal when you get the letter of findings and you disagree or the other party disagrees. You may do that, but the problem is that the appeal is due process, and that's not necessarily the ideal mechanism that a district might want to go into, because as we'll talk about later, if you do appeal and initiate due process, then the burden of proof is going to come down to you. So a lot of times there has to be a consideration, tactically speaking, about whether it makes sense to appeal or whether the findings are something that you can live with. A lot of times, I've done many of these kind of proceedings, and sometimes these corrective action and administrative complaints can be like more burdensome than going through due process. And so you may want to consider whether an appeal makes sense, or it's something you're going to have to deal with in the future or for other students. So sometimes it does make sense, but you should consider, just from a really practical standpoint, whether it makes sense to pursue due process to try to appeal. So one good thing about the administrative complaint process is that attorney fees aren't available. Now, other kinds of compensatory education or other kinds of, if it is filed pertaining to an individual student, other kinds of relief may be awarded, but attorney fees are not available under this process. And that's even if an attorney is hired to assist the parents in pursuing the complaint. And so that's just stated in the commentary to the regulations. And I've never seen an agency struggle with this issue. Now, I have seen parents attempt to take a letter of findings and then appeal through due process to go ultimately get their attorney fees. But as we'll talk about, there's a lot of resolution procedures that come into play when you're talking about due process. All right, I don't see any questions in the chat, but we're going to move on to due process, but feel free to ask if you've got anything. Okay, so due process. So I do find that when a due process complaint comes in, it's not always a surprise. It usually isn't. Sometimes they come out of left field, but usually school districts are aware of them. They are stressful to get. And I have even had times where some of my clients have gotten a few at once, and I've handled a few at once. One thing I would say when you get a due process complaint in is that you first want to pay attention to timelines, because there's a lot of stuff going on and you guys are very busy with your work. But timelines for due process are really important. Actually, because due process is administrative in nature, the timelines are quicker than even other forms of litigation. So you'll want to just be real aware of that. And we'll talk about, and that is timelines for things like getting a resolution session scheduled, getting documents ready to produce to the other party, getting witnesses lined up to potentially testify, getting your answer and other responsive documents submitted. So there's a variety of timelines, and we're going to go through each one. So the statute of limitations for due process proceedings is 2 years in general, but that is unless the parent was prevented from requesting a hearing because of a misrepresentation on the part of the district or withheld information that was required to be provided. I don't see those limitations periods exempted too frequently, but I will just say when there is any proof of that kind of behavior, a hearing officer is not gonna bat an eye about extending a statute of limitations. I do find that statute of limitations defenses, when they're clear and the limits are clearly there, they'll be enforced. But if there's like a question about the date that a parent should have known, or if there's any kind of unclean hands on the part of the district, hearing officers will extend it. And the reason that that's problematic and you want to avoid that is that it can make the proceeding more expensive because it just expands the scope of the hearing. But it can also make it more risky because the reason we have statutes of limitations is that memories, records, all kinds of things kind of can fade and become less clear over time. And so if you are going back for years and years and years, you may not have staff available to testify about the relevant issues. And if you don't have that, then you're kind of at the mercy of the parents' memory and how good their record keeping is. And some of these special education parents, I'm sure you've seen, keep good records. They show up to meetings with their binders and they know what they're doing. So it's just something to really pay attention to, that if you don't have the right kind of communication and the right kind of information provided to parents, then you can be putting yourself at risk. All right. So the notice. So what you're going to get with the due process complaint is you'll get a notice from the agency, and they'll first file a complaint, and then you'll get a notice from the agency regarding it. And that will usually include the assignment of the hearing officer, and then it'll state relevant deadlines and relevant actions that you need to take immediately. So one thing to be aware of is that due process complaints by regulation must contain specific information. They have to include the name and address of the child, the name of the school the child is attending, the available contact information if the child is homeless, a description of the nature of the problem, including relevant facts, and a proposed resolution to the extent known and available at the time. If that information is not in the complaint, then you may challenge the sufficiency of the notice. And this seems like a rote procedural step, but I have done it many times, and it can be effective. And the thing that I usually find is that the resolution is what is often missing. Now, sometimes there's weirdness with the identity or a confusion as to the parties. And this might come up if, like, for instance, the parents are divorced and the person who files doesn't actually have the rights to sue. There can be some issues like that with party that come up. But what I find most often is that the issue is not very well stated, or it's super unclear, or the resolution is the most commonly left off item. Now, the regulations say to the extent known, but I do think that hearing officers tend to want to understand what the issues are and what the parties want. And if they don't, they will ask the party to clarify and provide some more specificity as to their allegations. And the reason that this matters is that you're supposed to, one of the first things you have to do when you get a due process complaint is attempt to resolve it in a resolution session. If you don't really know what the issues are and what the parties want, it's very difficult, and you can't actually do the process the way that it's intended to do. Now, you should be aware, this challenge to the sufficiency of the complaint has to be filed within 15 days of receipt of the complaint. So that's not a very long time. So that is something that you need to, and if you have, for instance, insurance involved with the assignment of counsel, or you have to go retain other counsel to assist, then that's something that you need to get on quickly. So getting the right people involved to assist with the matter is essential, and you want to do it quickly. Now, the good thing is, if you do file a challenge to the sufficiency of the complaint, it can extend your deadlines, your other deadlines, and the regulations say that. So it may mean that your resolution period and then your other deadlines are postponed until it's addressed. The hearing officer is supposed to rule on that sufficiency within 5 days. And there's sometimes sometimes the other party wants to respond, and I don't think that the regulations really require that, but I have seen hearing officers generally allow it. But they do have their timelines, and sometimes I've even seen them do this just via email to expedite the process. But just be aware of these timelines and how essential and how quick this can move. Okay. So you still have to, okay, so a response to a due process complaint, assuming you have a sufficient complaint, you still then you'll need to do a written response to the due process complaint. And that's at least if the district has not provided prior written notice on the subject matter of the complaint. Now, in many cases, you will have done that. And we talked about prior written notice, I think, in the last ESELA session. So hopefully you were good on that and you're in the habit of doing prior written notice. But sometimes issues arise in due process complaints that actually were never discussed in IEP meetings. I have found that to be true quite often. And so sometimes the substance of the complaint actually relates to stuff that just wasn't discussed. And so that's a time when you might need to additionally provide a response. And one of the things that I have done is even when I have sometimes had creative parents attorneys who try to use procedures aggressively. And so what I have generally done is, even when I know my clients have provided prior written notice, I will still do a very brief response that says, we provided prior written notice to this allegation on this date, we provided it up to this allegation on this date. And then if there was something that wasn't provided, then we'll set that forth. But I generally do that just as a cue to the hearing officer that we are good to go. Let's move this along. Let's get it scheduled, and let's proceed with the other things. But it also is kind of a cover so that the parents can't say, oh, they didn't respond and they didn't follow the procedures and things like that. This has to be done within 10 days of getting the complaint. So so if you do file the motion for objecting to sufficiency, it'll be after the date where the sufficient complaint is filed. But you generally want to start thinking about this response very early on. Another thing just to remember is, when you get the complaint, the district must inform the parents in writing of any free or low cost legal services in the area. Okay, so one of the next things that happens after once you get a complaint, you get a response, and we at least know the parties' respective positions, is that a resolution session will need to be convened. This is within the resolution session is within 15 days of the complaint being received. But this is something that can be amended. What I have generally learned to do as counsel who has handled these things is, as soon as I get the complaint, as soon as I get it in, and even before I've otherwise responded in writing, I will email the parent's attorney or the parents if they're not represented, and just say, let's get this resolution session scheduled. I just put the ball back in their court as quickly as I can. It's something that it's a 1-minute email, and it kind of takes care of that thing. So I do this short task right away to make sure we just are moving the ball forward, because I do find, especially even if lawyers are involved on the other side, lawyers and scheduling is something that can sometimes be a nightmare. So you want to make sure that you're able to demonstrate your willingness to comply and get something set up. A thing to consider on the participants. So with resolution sessions, this is one of the times where it's a little bit weird in terms of kind of a deviation from the general rule. So the regulations say that members of the IEP team who have specific knowledge of the facts identified in the complaint, including a representative with authority to bind the district, have to be there. And I think one thing that I would just consider, that's not super clear in terms of who that is. You want to have the people there that can provide information and that can discuss the issues thoroughly, and that can bind the district in terms of a resolution, a settlement, basically a settlement agreement of the deal. But one thing I think you should consider is, and one thing I always consider is, who is going to help us actually work with the parents? If there is somebody that is a lightning rod to the parent or the parent's attorney, maybe, and maybe you can fill that role with another person. It may be good to have the people there that have the better relationship, that can work on actually fixing this, that have some trust with the parents. So just something to consider about who's there. Another thing to consider is that council, a resolution session is one of the times where an attorney for the district is not supposed to be there if the parents aren't represented. Now, normally, and we even have law in Ohio on this, the school district generally has the right to have an attorney represent them in due process. It can have an attorney even be present at IEP meetings when the parents aren't represented. I don't usually recommend that for a few reasons, but it can. In resolution session, though, you're not, okay? So if the other side is not represented, then you should not have attorneys present. Now, you may need to get your attorney involved with, helping with the agreement after the fact, but it's not something where they should be there. There can be a perception of an imbalance in power or other things. Sometimes I do find that coming to a meeting when the parent is not represented, it sometimes just puts them on the defensive, and they don't necessarily know how to process it. So it can be a challenge to do that. So one thing you should be able to do, though, is you can consult with your attorney before the resolution session to think about potential ways to resolve an issue, to talk through the issues, to understand the nature of the risk at play. You can do that before. They just shouldn't be there if the parents aren't represented. The regulations say that the resolution session is mandatory unless both parties waive. And I generally don't recommend waiving. I have had sometimes parents say, we don't want to do it, we are just not interested. But I generally will try to just do the resolution session, and I won't waive it unless there's a real reason to do so. I do think like the intent of this statute is that it's resolved and the parties work together to come up with a solution. So I think it's worth it to go through that. Now, sometimes you'll walk in and it'll be a 5 or 10 minute resolution session because it breaks up very quickly. But generally, I think it's worth it to try. And my goal in resolution sessions, usually, and the ones that I am able to attend, is to try to listen and understand what the parents want and create a dialogue. And just as a practice tip, you will probably have demands made in a resolution session that may be things that cannot be obtained in due process. You may have somewhat ridiculous or exorbitant demands for compensatory education and other kinds of relief. And generally, my strategy has been to try to be as non-judgmental and open in listening to these demands as I can. Because usually if I can at least get a list of demands from the parents, I can at least get a sense of what their real interests are and what they might be interested in exploring. And then what happens is I may work with my client, whether at the meeting or separately, and we can try to craft a deal. And we'll talk a little bit later about some other things, but there is something called a written offer of settlement, and I've used those a lot. So even if the parents reject what I offer, there is the ability to make a written offer that can mitigate the risk of attorney fees. So generally, I would say try to be non-judgmental, focus on the future, and figuring out how we can solve this problem. Now, you can adjust the resolution period too. The timelines for this period are pretty short. Once you get it done, I believe it's 30 days, but like you can extend this. And I've even done this unconventionally where we met in person for a resolution session, and then we convened via email and sent written things back and forth, written offers or demands or however you want to characterize it, back and forth. And we would construe that as a continuation of the resolution period. You'll want to update your hearing officer of what you're doing so that they know. You have some flexibility with this. And I generally find that hearing officers want to be flexible when it looks like parties are working together to try to solve a problem, because it's one less hearing that they have to manage. And the reality is, parties coming up with a solution that they can live with, whether they love the solution or not, it's going to be better than a hearing officer's decision. I'll just tell you that. Parties in control of their own destiny, and figuring out what works best for them and fixing their relationship together, they're gonna do a better job for the student and themselves than a hearing officer can. And that's no disrespect for a hearing officer, but the hearing officer just doesn't know the same amount. They're looking at the record only. They have limits on what they can do. And the parties can actually be a little bit more creative and flexible at the beginning as opposed to after due process. All right, so let's talk about due process. So the timelines for decision are 45 days. I find that this can be extended, and it often is, depending on the availability of the parties. But you need to be aware of these deadlines, because sometimes they can't be extended. And sometimes they actually, for whatever reason, because of the availability of people's schedule, they might happen really quick. So when you get a due process complaint in, you need to act like you're getting ready for the hearing. So even while you're trying to resolve it, you should be gathering documents, you should be getting things ready, you should be lining up witnesses to disclose, to get ready for the hearing, and then to meet these deadlines if you have to. If you have an expedited due process hearing, and that is limited to certain scenarios, usually arising out of a disciplinary situation, the timeline for expedited hearings is 30 days. You have 20 days to do the hearing, and then 10 days after that for the decision. Now note, expedited due process hearings are only on specific issues. So if you get a far-flung, broad-based due process complaint that addresses a number of things, including those that are supposed to be expedited under the regulations and then other items, it may be an idea to challenge that, or to try to sever the issue so that you only address the expedited issues in the expedited hearing, to make that process somewhat easier, and then you can do the other issues later. I know the idea of multiple hearings or multiple periods of hearing is not something that is appetizing to anyone, but given that you may have limits on time in terms of preparation and focus, you may want to consider that as an option. And so you should be aware about resolution sessions as well for expedited hearings. Those regulations still apply. You still need to do a resolution session, but the deadlines are compressed, so 7 days. So that's another reason to get in the habit of, as soon as you get that due process complaint in, sending out that communication to try to set up the resolution session and get things moving, because you don't have a lot of time. So the failure to participate in a resolution session, there can be consequences for both or either parties. And I've generally not had this problem. The closest I've really come to this is the parents not really participating in the resolution session in good faith. And to the point where they walk in, they sit down for 5 minutes, they make, they basically just express vitriol instead of making any kind of real demand or talking about any kind of real interest, and they walk out. And those have been times where I've considered with my client whether we want to try to pursue something with the hearing officer to force the resolution session in a meaningful way or not. But there are some consequences for not participating in it. So one is that if you don't get the resolution session done, the due process proceeding can be delayed. And the real problem with delay of a due process hearing is that it can leave you in limbo. If it is a situation where you have stayed put in place and there's a placement that either is not good for the student, not good for staff, or potentially expensive because it's maybe a private placement scenario. It's something where delay, you don't want to be dealing with that. So you want to get the session done so you don't have that problem. The other thing is, so parents can actually, if parents do not participate in resolution session, there is an option to ask the hearing officer to dismiss the case. I've not seen that exercise because usually my experience is they'll just order the parties to do it by a date certain, and then it usually gets done. But that is a potential, hammer you have. So in communicating with parents, if they say express an unwillingness to do it, you can remind them that it has to be waived by both parties, and that dismissal is a potential option if they don't participate. And so that usually gets people in line. If the school district fails to hold the resolution session, the parent can seek intervention of the hearing officer, or just say, let's just begin the timelines. So, that means they can just get the hearing set up. And one thing to just be aware of, when litigation is filed, the party filing kind of has an inherent advantage because they may have their counsel already lined up. Their counsel probably has already looked at things and crafted a theory and understood the case in a way that the school district may not, because they are just getting it. So a lot of times, if this hearing gets kind of pushed forward more quickly, it can be to the disadvantage of the district. And we'll talk a little bit more about why in terms of some of the document deadlines things next. Okay. So if you resolve issues at the resolution meeting, you want to have a written agreement signed by both parties. Now, this can be something that might be a little bit technical. I generally, when I am doing these for client, I do include language of release, and I include some specific language. So you generally will want to have the assistance of an attorney helping with this. But one thing you can do, even if attorneys are not there, is you can have a brief statement of the agreed terms. And then, at the end of it, say a formal settlement agreement will be, prepared and agreed by both parties subsequently. I generally want to do this because I have had cases where due process has been settled, and then parties have attempted to bring the case back. Now, and sometimes they've tried to say that it's a breach of the settlement agreement. But if it's a breach of the settlement agreement, usually in your agreement, you can state where those should be enforced. And those agreements under the regulations are supposed to be enforced in court and not in a due process hearing. And if you're talking about the breach of an agreement, you want a court to do that, because courts understand how to do contract interpretation better than hearing officers probably do. So you want to be careful with your written agreement and get the assistance of legal counsel to help on that. So the subject matter for due process hearing, the regulations explicitly talk about the fact that you can't raise issues in a due process hearing that were not raised in your complaint, except by some agreement of the parties or potentially by a waiver. And you should be cautious about this. Like, as the district, you don't want to raise issues that weren't raised, and be cautious about a waiver of the argument that it wasn't an issue. But I'll also say this, like, sometimes it happens in due process that they aren't really raising IDEA issues. And the regulations are not so obvious and clear on that. And you might have to be a little bit more, use a little bit more art in terms of identifying this. But the hearing officer's jurisdiction in a due process hearing is not civil rights under Section 1983 or the Americans with Disability Act. It's not even Section 504 of the Rehabilitation Act. That's a separate process. So you may, and it's not also negligence or some tort of like assault or battery or something that may come up if it's a case that has restraint and seclusion potentially. So one thing to keep in mind is if it's not in the complaint, it should not come up because it hasn't been pled. But another aspect of this is hearing officers have limited jurisdiction in these proceedings, and they don't consider all potential issues that arise under school law. And frankly, you don't want a hearing officer making a finding on these other issues first, because it can present other complicating issues down the road. So keep the focus of the due process hearing limited for tactical reasons, but also just to not expand the scope of this hearing, exponentially. So the disclosure requirement relates to documents. So parties have to disclose pretty much everything they're going to use at the hearing 5 days before the hearing. Now, many times hearing officers may do scheduling orders that kind of make this disclosure process happen quicker than 5 days before. And sometimes the parties may actually work together, and ideally you will work together to, especially if the other side is represented, to craft a schedule for disclosure of exhibits. Ideally, you will be able to work with your opposing counsel enough to have like designated joint exhibits, and then you'll have the parents' exhibits, and then the respondents or the district's exhibits. So if you have those deadlines in place in a scheduling order or an agreed order of some form, you want to comply with those orders in addition to the 5-day rule. Now, sometimes what happens is you have your scheduling order and then some additional information comes up, or you realize something was omitted inadvertently. You want to get that in before the 5-day rule at a minimum. The 5-day rule in the regulations is jurisdictional. If you don't comply with the order, then the party has an argument to exclude something. The hearing officer may have discretion to exclude something, and you don't want to have that risk. So just be aware of any other orders that come up in the case, and you want to comply with both of those. But I have had way too many 5-day fights on my hands, and it's not something that you want to be dealing with. You want to know what's in play and what's not as you're prepping, and it can be it can be a hard surprise to learn that you can't rely on something that you need. So really being cautious about identifying the relevant documents, who's going to testify to them, how they're going to get in, and what you need on the front end is a way to avoid some of these challenges. Okay, so the burden of proof in due process hearings. So this is on the party seeking relief, and there's a case from the Supreme Court of the United States on this, Schaefer versus Weiss, that tells us this very clearly. So what that means is that usually it means it's the parent's burden in a hearing. Now, if it is a case where the district has pursued due process, for instance, if they have not been given consent to do an evaluation and they decide they need it, but like if that is the case, that the district actually files for due process, or as we talked about, if you are appealing an order, a letter of findings from an administrative complaint, if the district has initiated it, then they have the burden of proof. But generally it will be the parents, because usually they're the ones filing. And what that usually means, if you break that down, at least I've made the argument as an advocate, is that the parents have the burden of showing a violation of the regulations. So they have to present facts to support a violation, and they have to persuade the hearing officer to believe that their interpretation of the regulations and their application of it is correct, and that a violation occurred. But then I usually make the additional argument that they also have to show that any relief that they've demanded is appropriate. And so it generally includes both things. But I will say, and now this logically should mean, and it's usually by a preponderance of the evidence. So, it's just about like a little more than, half the evidence is supportive of their position. But you should be aware that if the district is defending on any specific factual grounds, if it is trying to argue that its decisions were reasonable and appropriate, even with the burden of proof, the hearing officer is going to expect you to back that up. So, you know, what the burden of proof means is that the district doesn't really have to come in and prove a negative, but the reality is you're going to come to these hearings, and you're going to be offering explanations for what you're doing. So, you know, you'll need to think about whether you have the documents and the people to back that up. And I think like you should be, one thing that I have done as an advocate is just consistently educate the hearing officer at every turn that the parents have the burden of proof. And I try to do that because in general, and this is not a criticism of hearing officers in any stretch, but they are human beings. And these students, and these parents are often very sympathetic and they do have needs. And hearing officers are very concerned about ensuring those needs are met. So they'll be looking at the district's explanation and their evidence with a critical eye to ensure that the student gets what they are entitled to. So, you know, consider this burden of proof for yourself. So can the parents establish that something wrong happened? Can they establish that, you know, there's at least an argument that the relief they're asking for is worthwhile? And then, you know, and then consider what your answers are going to be to that and whether you can convince a third party you don't know that you're right. And so I think if you consider this all along the way, it probably will help you figure out and see things a little bit more objectively at the settlement phase, and then even as you're preparing for the hearing. Now, if you get a due process finding from a hearing officer that doesn't go your way, and I find this happens, and sometimes it happens because there are, you know, reasonable minds can differ on issues. Sometimes it happens because mistakes have been made. But if it happens, there is the right to an appeal to the state level review panel. And that generally is done by brief. There are some limitations on what the review panel can do. They cannot like make new findings on factual evidence, right? So they can interpret the facts in play differently. But if it's a matter of a credibility determination by a hearing officer or something that directly relates to how they perceive the testimony of a witness, there can be some limitations on that. So a lot of times the appeal is a thorough review of the record to make sure that the decision is legally compliant, you know, based on a good review of the facts. But it doesn't necessarily mean you're really redoing the hearing over. So the point of this is do a good job in the hearing. Okay. It's important to have the right people there. It's important to have the right documents in play. It's important to assert the right legal defenses and the right legal ideas in your responses and your written pleadings and post-hearing briefs and things like that to make sure that the hearing officer, you know, you want to get that right first. If either party doesn't like the state level review panel's decision, then there can be an appeal to federal court. Now, you should be aware that once you get into, and it's usually federal court, sometimes it can go to state court, but usually it ends up in federal court. And I would tell you the federal courts, they don't know, they aren't special education experts, but they generally know it a little bit better than the state courts because IDEA is a federal statute. So generally I would prefer these to be in federal court if it was my appeal. And then the thing is, though, there's a lot of deference that the courts have to give to the state level review panel. So what is that telling you? The hearing is important. It's the most important thing is getting the right stuff in the record. You can get reversals and you can get courts to if it's an issue of law, you can get courts to see it the right way. And they have a little bit more ability to kind of look at the broader body of IDEA law and authority from other jurisdictions too, that a lot of times hearing officers and state level review panels may struggle with a little more. But that hearing and that record stays intact. You can add to that record, but there has to be a really specific reason to do so. And I find that courts are often reluctant to do it because they're not really set up the same way an administrative agency is. All right, Kristen, can we go on? All right, our favorite topics, attorney fees and stay put. So I have done some attorney fee proceedings in court. And I have, because I've, sometimes you don't necessarily always get the best result. It's generally something you want to avoid, I think, because, if you can settle the case early on, you'll take care of attorney fees in your discussion and your settlement discussion, and hopefully you keep that number real low. If you end up getting through a hearing, these are essentially almost like trials, and sometimes they can take a week or more. So that's a lot of attorney time. So attorney fees can go to the parent if they are a prevailing party. And prevailing party means they won on any issue alleged in their complaint. If they allege 15 issues in their complaint and they win on one, they are a prevailing party. That means they are entitled to attorney fees. Now, you may argue about what is appropriate, whether they overbilled, whether their fee statements are good enough to really evidence what they've done, but they still are a prevailing party. So you won't be able to knock that out. So you may end up in a fee proceeding, even if overall the parent they lost on 14 issues, but they won on one. So this is why I'm talking to you about the importance of trying to resolve things. I did mention offer of settlement, and it is a device I've used a lot. If you make a written offer of settlement to a parent, and this is like after resolution or mediation have failed, and you really, and they just won't work with you, you can make a written offer of settlement to the parents. And if they don't beat your offer at the hearing, they are cut off on fees from that point forward. Now, when you do this offer of settlement, you generally need to make an offer of fees to date, reasonable fees to date, to make that binding. But it is something I pretty much I've used in almost every proceeding I ever did. And it has been effective. We don't always get the parents, they usually don't just accept your offer, but a lot of times when you make it, then they say, okay, well, we'll work with you. We won't do that, but we'll do this. And a lot of times we can get it settled. But if you don't, I have had times where they rejected my offer. They went to hearing anyway. And the court said, oh, well, you went to hearing and you won, but it wasn't any better than what you offered. And they limited their attorney fees substantially. So it's a good thing to do. So my clients will ask me a lot, like, this is ridiculous. Why are we going through this? Can we get attorney fees? You could, in theory, but it is really rare. And just think about it. A school district going and getting attorney fees from a court against a child with special needs and their parents. It's not something that's going to happen lightly. It will happen if the complaint is deemed frivolous, unreasonable, or totally without foundation. And if it's presented for an improper purpose. That does happen in the realm of special ed law, and there are cases out there that fees have been awarded to districts. They are exceedingly rare, and what you got to consider is if you are pursuing attorney fees against the parent, you will have to pay your attorney to get that. That can ultimately be obtained later too, but that's part of your risk analysis. So it's just something to think about. Like, you are probably not going to be able to recoup all your expenses for most due process hearings if you choose to move forward. So your expenses in litigation, and I think Erin's going to talk about this, that's part of kind of the consideration in settlement and part of what should motivate you to settle. So another thing to think about is stay put, and I've done some weird cases on stay put along the way, but it is something where generally the child has to remain in their then current educational placement during the pendency of any administrative or judicial proceeding. Now, be aware that stay put can shift during the course of the proceedings. So if there is some law on like that, once the state level review panel affirms the hearing officer's decision, that then can become the stay put placement. So it can shift. So if you have a change in placement in the course of litigation, you need to have your counsel drill down on whether that's what the stay put placement is now, and you'll want to have clarity on that. Because there is some tension in the law there, and just be aware of that. But generally, it means the student stays where they are the whole time. So if it is a situation like you're talking about with tuition might be in play, or other kind of expenses for maybe transportation, it's something that you'll need to just think about and factor in as you're assessing settlement. And it's just not something you want to mess around with, because generally hearing officers, you can convince them that something that the stay put placement is maybe different than what the parents are suggesting. But generally they're going to be expecting that student to remain in the same place. So if that is not the case, then you'll have to have a real good explanation for that. Okay. All right, so facilitated IEP meetings. This is one mechanism that you may have, most likely before you get to due process or a formal complaint. It is something where it can be used at any time. You have to have the mutual agreement of the parent and the district to participate. And you can get a trained facilitator at no cost from DEW or OEC. And what the point of the facilitator is, this is not the same as mediation, and it is not the same as a hearing, because the facilitator doesn't make a decision. It doesn't tell the parties what to do. Instead, what the facilitator will more likely be doing is listening to both sides and trying to help promote communication. So somebody with some training in that area can be helpful to try to avoid the hearings and processes I'm talking about. But it may be at least worth an attempt. But it is not something where you have a guarantee that the situation is going to be resolved. I do think that, as I've said before, any attempt that you can make to repair relationships, solve a problem on your own, it's something that is worth considering. So let's talk about mediation next. And we are getting close to our break, so just hang in there a few more minutes. So mediation is another one that can be used at any time. I find that most commonly it comes up after a resolution session. A lot of times parties want to try the resolution session first and see if they can make headway, or at least identify the issues that maybe they'll bring up in mediation. But again, both parties have to agree. DEW, OEC will provide a trained mediator at no cost. And if the parties reach agreement, they want to create a legally binding and enforceable agreement, much like we talked about earlier. And under the regulations, though, be aware that a mediator does not enter an order or opinion and doesn't really arbitrate the proceedings between the parties. Again, the mediator is someone that helps to not just communicate between the parties, but helps to find the common ground and focus on the interests instead of the positions. It's supposed to be a confidential process, so generally anything said in settlement can't be used in a subsequent proceeding. But if you have required changes that are agreed to in a mediation, you need to get an IEP meeting convened within 20 days to implement those terms. So one thing to think about with mediation, and I've said this before, but it also comes up with mediation, is consider if you are creating a legally binding settlement agreement. And I think in general you want to, right? Sometimes there are times when you might mediate and settle a portion of a case and not the whole thing. But if you are going to the trouble of mediating and you're offering relief and sometimes paying attorney fees, I really encourage you to make the goal the legally binding settlement agreement, because it's really the only way to ensure that the issues are not coming back. So I encourage you to involve your legal counsel for doing that. It is something that does require the expenditure of money if they aren't already involved. But if it means that you can dispense with an attempt at bringing litigation back in an easy way, it is money well spent. So I do find that some mediators within these agencies are not lawyers. And so sometimes they're real focused on conflict resolution, but they don't understand the legal processes as much and don't understand the legal risks of not having an agreement. So that's where your counsel can be of assistance to you in crafting an agreement that is fair, that captures the term accurately, but does truly resolve the litigation. So a few practice pointers. on this, I just lost my place, sorry. You want to get the agreement in writing on each issue. And it kind of can help you get some momentum in feeling like you're making progress as well. You know, if there are disputed legal issues, then, you know, there can be times where, you know, there can be an inability to, you know, move past it. So what you might want to consider is whether you will focus the energy on the deal breaker or make more extensive offers or alternative remedies in exchange for a compromise on the deal breaker. So you may have to figure out if you can work around that issue or if you maybe just have to deal with it. But as I've kind of said, I hope this whole discussion of the process makes you a little less afraid of it so that every issue doesn't become a deal breaker. Because to be honest, sometimes in a mediation or a resolution session, it just makes more sense to go ahead and litigate it because of how unreasonable or difficult the parent is or how unwilling they are to see anything, you know, your way. And if their demand is so exorbitant that you can't live with it, then you know the next best thing is to litigate. Decision makers need to be in the mediation, and that's one thing that does come up. If you have insurance potentially that, you know, might come in and be able to pay for some things, usually that's not as available in special education, but sometimes it is. You want to at least have access to them via the phone. But anyone who is going to be authorizing money or any kind of offers of relief needs to be there or at least be available to help discuss it. Excuse me. So mediation and resolution, it's not supposed to be adversarial. Now, you will have parties come in with a combative attitude. You will have those kind of discussions at times. And I encourage you to not necessarily respond in kind. I encourage you to try to be open and flexible and creative in your approach. Generally, I have seen parties try to do opening statement kind of discussions early on. And if the other side really wants to do it, I generally will listen because I think it helps them move past whatever they're going through. But I generally keep my remarks very brief on behalf of districts. And I generally just say, we understand, we hear, we may see things differently, but what we're trying to do here is to move forward and resolve this so that everyone's in a better position going forward. So I generally say, let's avoid the combative fighting kind of things. You may have some breaks and you should have some ability to meet privately with your counsel or your crew to kind of discuss. You shouldn't necessarily have to do that in front of the other side. And if you have to ask to take for that privacy, I think it's worth it to do. So I have found some mediators who want to bring everybody in the same room all the time. And sometimes that works, but it's not always effective. So if you need something different, make sure to ask for that. And I do think that there's a lot of emotions in these processes. And I think you should be ready for that. But I will say that I would not necessarily mirror it. I would instead kind of receive it, make space for it, allow it to be there, but then think, how can we create a situation that avoids some of the stress? How can we actually fix some of these problems if you can? And I think that's generally the better approach. Okay. Another thing is for mediation, they can take a long time. So plan, like, you know, take breaks if you need lunches, have some snacks there. Just take some breaks to take a walk outside real quick or, you know, get some air. That can be something that really is helpful. And then consider whether you need to convene an IEP meeting to implement anything. And that's something that you may need to state in your agreement to make things work. You may need to consider the procedures of, like, if you are making reimbursement, how is that going to happen, and all of those kind of things. And then, as I said, consider whether you have good release language. And Kristen, I'm ready to move on to the next one. So I'm sorry I've paused a few times and confused you. So we can go on to administrative review. All right, we're almost done. So administrative review can be requested by parents or another person. Once requested, the superintendent shall conduct a review, may hold an administrative hearing, and shall notify the parties within writing. So this option is not available for districts to request. It can only be requested by the parents or by another educational agency. And where the child is placed in a program operated by a county board of developmental disabilities or other educational agency, the superintendent must consult with the administrator of that board or agency. And the administrative review has to be conducted at a location convenient to all parties. And every effort should be made in the review to resolve any disagreements. And the thing that you should be kind of cautious about is that administrative reviews cannot be used to delay or deny a due process hearing request that has been made in writing. All right. So other dispute resolution options, these are some things that you can do, whether sometimes this is when there is a due process, sometimes it is when you just notice disagreement arising in an IEP meeting, or sometimes it can be like parents are expressing concerns to you via email. Holding an IEP meeting is always an option. The regulations say we have to do a certain minimum number of IEP meetings a year, and we have to do them in certain circumstances, but there's nothing that says we can't do them when necessary. So holding an IEP meeting, I think it just is a signal to parents that we are willing to look at things and make some changes if needed. So it's a good option. Propose reevaluation. Sometimes parties disagree because we don't have all of the facts. So getting some more facts and understanding about a student can help us. Proposing reevaluation through an outside evaluator. I have had this come up where, sometimes there are experts who the districts trust and the parents trust, and maybe we allow them to give us some input that might be supportive to the student and help the district avoid further conflict. So those are some additional options for resolution. I also think like just creating new communication plans, and considering other kinds of supports and services that, haven't been considered. Those are some other options too. All right, so I think I am about done. But we just have a list here of some few additional resources. So updates from DEW in your SST. There are special education legal updates. Special Ed Connection is a great resource, especially their daily news email blast. The Council for Exceptional Children has some good resources. Rights Law has some as well. That is parent focused, but they have some good stuff. And I find that some of the Department of Education, the Federal Department of Education updates, modules, training, and resources are excellent as well. So at this point, I think I'm finished. I didn't get any questions, but I think Erin's going to take over and you're going to get your break.
Thank you so much, Claire. Yeah. Do you have maybe another 45 seconds to hold on just to see if we get any questions?
Yep, I'm good.
Great. Okay, great. If we don't get any questions in the next minute or so here, then we will just go ahead and take our break. Oh, we do have one question, Claire. Can anyone file due process or only parents?
It's not only parents, it could be a guardian, but it has to be somebody that has authority over the student. So in theory, a student who is 18 and capable of asserting their own rights could do it. But it usually has to be someone affiliated with the student. And this can come up in due process about whether they meet the definition of a parent or whether they have the requisite legal authority. But yeah, due process is restricted in that way.
Great. All right. Well, I haven't seen any other questions come in, so let's go ahead and take our break. Why don't we come back at 10:30, and then we will talk about the top 10 issues in special ed that we see creating conflicts. Okay, by my clock, it is 10:30, so I'm going to go ahead and get started with the second part of our session today. So I want to start by talking with you about the top 10 special education issues we see that trigger conflict. And in case you missed the first few minutes today, because Claire and I had to step in at the last minute, we kind of switched the order around. So now we're going back to the start of your materials in case you're confused about that. Okay, so the first item on our list here is not taking appropriate action in response to bullying and disability-based harassment. And we'll talk specifically about disability-based harassment today because this is a special education themed session, but the same, we see this get missed a lot with other types of harassment based on protected classes like race and gender. So this applies to all of those protected classes. So but today we'll just talk about disability harassment. So if you attended the ESELA presentation about Section 504, you would have heard my colleague talk about the legal protections that students with disabilities have. Those protections exist to protect so that students with disabilities do not experience discrimination and harassment on the basis of their disability status. So what could that look like? It could be disciplining a student on the basis of their disability. It could look like other students teasing that student on the basis of their disability. So imagine a student with a peanut allergy and kids are throwing Reese's Pieces at the student because they, weren't allowed to have certain candy at the Halloween party because of the student's allergy. That would be considered harassment on the basis of a disability. So resolving those types of complaints can be extremely costly because they can end up in federal court. So how do we avoid that? What I would encourage each of you to do at the end of our session today is to review your board or your district's policies about disability discrimination. In that policy, there will be at least one, sometimes two people named whose job it is to investigate and respond to these complaints when they come in. So if you see something that you even slightly suspect may be harassment on the basis of disability, discrimination on the basis of a disability, you should report it to that person identified in your policy right away. If you are that person and you get one of these reports and you have no idea what to do, I would encourage you to consult with your legal counsel to immediately initiate an investigation. And we help a lot of districts with this. Some of these complaints don't come in all the time in a lot of districts. And so we'll have the person named in the policy call us and say, oh, I just got one of these complaints and I have no idea what to do. And that's totally fine. We do know what to do and we can help you through that, or your legal counsel, if it's not us, almost certainly can help you through that. If the student or their parents end up filing a complaint with the Office for Civil Rights or with a federal court, the first question that's going to be asked is, did you as the district investigate it? If the complaint was substantiated, how did you respond? So it's going to be on us as the district to show that we were not deliberately indifferent to that complaint of discrimination. And the best way to do that is to initiate a prompt investigation into that complaint. So that's a big one that we see get missed a lot. So the number one thing you can do, again, is look at your board policy, identify who is supposed to receive these complaints, and make sure you report it to them if you get a complaint like that. The second issue is failing to understand your obligations regarding non-academic and extracurricular activities. So in 2013, so this is over 10 years ago now, the Office for Civil Rights issued guidance clarifying that students with disabilities are required to have equal opportunity to participate in non-academic and extracurricular activities. What does equal opportunity mean? It means just that they must be given the same opportunity to participate. It does not mean that a student with a disability is guaranteed a place on the basketball team, for instance. It does not guarantee them a competitive advantage. Instead, what you are required to do is conduct an individualized inquiry, so an inquiry based on that particular student, to determine whether that student can participate in the extracurricular they're interested in with certain accommodations or modifications, or whether that change would constitute a fundamental alteration of the program. So for example, if a student has asthma and needs to have their asthma inhaler with them during basketball practice, that is probably not a fundamental alteration. But if the student is not able to walk or run, that may be a fundamental alteration. This one typically doesn't get missed for students on IEPs because, as you know, there's a section in the IEP that addresses this, but it can get missed for students on Section 504 plans. And it's also important to remember that Section 504 protects all students with disabilities, whether or not they have a Section 504 plan or an IEP. So in the example that I just mentioned, a student may have asthma and they may not need any accommodations or specially designed instruction as a result of having asthma. But because they have a disability, they would still be protected from discrimination on the basis of that disability, and they would still be entitled to an equal opportunity to participate in non-academic activities. So that's another area where we see things get missed. This student is known as a technically eligible student because they are technically eligible for Section 504, even though they don't actually need a plan because they don't have any accommodation needs. All right, next slide. All right, our next issue is about knowing when to ask for help. Most problems that we confront in special education can be solved, but they get much harder to solve when someone who should have asked for help does not. So we can probably all, I know I can, think of a time when we should have just asked someone for help instead of trying to do it ourselves. So what are some areas where we often see a need for help? So one way to have tools for asking for help within your organization is to develop internal expertise. So for instance, in our education group, we identify issues that we see a lot and assign those areas to certain attorneys. So it's impossible for all of us to be experts on every aspect of special education or every aspect of education generally. So for instance, we have a couple of attorneys that stay up to date on transportation issues. I stay up to date on teacher workload issues. Other attorneys stay up to date on Title IX issues. So when one of us gets a question that's outside of our area, we can consult our list and know immediately who to call to get help. I would strongly recommend doing that in your district as well if you're not already. Maybe one person in your group can be an expert in students with hearing impairments. Another can focus on procedural issues. Another could focus on reading interventions. Whatever the areas are that you are seeing a lot of concerns, that way you know who to call when you need help. Another thing we see a lot is issues in responding to outside experts. So all of you are highly trained, very skilled individuals, and so it can be difficult when an outside provider wants to come in and tell you that you aren't doing something right. But in many circumstances, this information can be really helpful. And there are, of course, consequences to ignoring it sometimes. So if a parent brings information to an IEP team meeting from an outside provider, you would need to include that in your team's discussions regarding the student's needs, for example. And if you receive a request for an independent evaluation, as you know, you have two options. You can say, yes, here's the criteria for our district for getting an IE, or you can file due process and say, we're not gonna grant your request. That's pretty rare outcome to say that we're not going to grant your IE because it's usually less costly to just grant it than it is to file due process. So I think most of us view, especially when it's a student we've been working with for a long time, we've been doing our best for, we can view an IEE request as a challenge. But if you keep an open mind to it, not only is it likely to benefit the child, but it will help from a compliance perspective. And finally, it's important to know when to involve a lawyer. We are here to help, and sometimes as Claire mentioned, the sooner we get involved, the more help we can be. All right, next slide. All right, our next issue is child find blunders. There's no such thing, as you know, as out of sight, out of mind in special education, where we often see issues in truancy and behavior problems. So you might say, well, the student does fine when they come to school, so it's not a disability, it's a truancy issue. But are we missing a disability that is causing the truancy? We see that get missed a lot. And with behavior problems, I was a teacher before I was a lawyer many years ago. And when I was a teacher, if a child was not behaving themselves in the classroom, we just sent them to the principal. But of course, current education theory is if we wouldn't send a child out and tell him he can't come to school until he learns to read, similarly, we shouldn't send a child out and tell him he can come back in when he learns how to behave. It's our job to teach the behaviors that we want to see And behaviors that are interfering with learning are in almost all cases a child find issue. So that's another one that we see get missed a lot. Finally, we will see issues with high academic achievers. So you can have high achieving students who are struggling with communication, social emotional skills, interacting with peers. Don't ignore those needs just because the child gets good grades. The next issue is ignoring 504 rights. So we touched on this earlier. Remember that some students may have a disability that does not require an IEP or a Section 504 plan. So for instance, the child we discussed with asthma, but their asthma is easily managed by an inhaler, they're getting good grades, they're participating in extracurriculars, they have lots of friends, they get along with their teachers. That child probably does not qualify for an IEP and does not need any accommodations that would be in a Section 504 plan. But that child still has a disability under Section 504 and is still entitled to those anti-discrimination, anti-harassment protections. So again, these are known as technically eligible students, and it's important to watch out that they are not experiencing discrimination or harassment, and we're not turning a blind eye to it when we see it. All right, next slide. So our next issue that we see is making a decision based on anything other than the needs of the child, and that includes predetermination. So if you say, well, we have a speech therapist, but they're only there on Tuesdays, and the only way to get everybody in this building who has speech needs accommodated on a Tuesday, we have to limit it to 30 minutes per kid. Well, not only is that not individualized, that's predetermining. So we would have a compliance issue there. What is predetermination not? Predetermination is not preparing for a meeting. Preparation is not the same as predetermination. It becomes predetermination when you've already decided without considering the parent's input or the individual needs of the child. So how do we get a lot of predetermination allegations and complaints. And so how do we show that we didn't predetermine? So this is where it's great to have documentation. So often there will be changes, for instance, between a draft IEP that you sent the parents a couple of days before the meeting and then the final IEP that you implement. So when we can show the changes between those drafts, that can help us show that we did listen to parent input. Being able to show, if you document in your PRO1, for instance, hey, parents requested X and we allowed X, or parents requested Y and we didn't agree with that for these reasons, that can help us fight a predetermination claim. Another thing to document is that you at least considered every request. So as I alluded to just a minute ago, consider does not mean you agree to every request. The standard is just that you consider it. How do you show that you did that? Again, documentation. That's where your PRO1 really comes in handy. You can document that there are things the parent asked for that the district did not agree to and why. So like having multiple IEP drafts, this can really help you when the Office for Exceptional Children comes knocking on your door. So finally, it is important to respond appropriately to parent requests that come outside of an IEP team meeting. So sometimes a parent will send a request for speech therapy or whatever to the principal or someone who they think has decision-making authority who might not be on the IEP team. So remember, those decisions need to be made by an IEP team. So it's important for that principal to respond appropriately and document the response, right? This decision must be made by your child's IEP team. I've copied your child's special education coordinator or whoever on this email to schedule a meeting. Please share with us any data or reports you would like us to consider at the meeting. Sometimes when these requests go to people who are not a special education specialist, we see errors get made. So it's important to make sure that our non-special ed administrators are trained in how to respond to these requests as well. All right, next slide. Okay, on our next slide, we have something that I touched on earlier, which is ignoring mental health and behavior needs. Remember, if we wouldn't send a kid home and tell her to come back when she can read, we wouldn't send her home and tell her to come back when she can behave. We have an obligation to address behaviors that are interfering with the learning of our students. And this is often going to show up in students with mental health needs. Next on the list is communication errors. So this is a big one that we see. Remember that your emails, because you are a public employee, those emails are public record. And those emails may also be a student's educational record if you are talking about a student. That means that the public generally and the parents of that student must be given access to those emails upon request. So when we have a client who gets requests for records from the public or from a parent, often my job is to gather all of the emails that might be responsive to that request from the district and review them to determine what needs to be turned over to the parent or the member of the public who requested them. And almost always there's an email or two or five that are potentially embarrassing or even incriminating. But I have to produce them to legally, and to add kind of fuel to the fire, salt in the wound. Most of the time, if a parent is making a records request, it is not because everyone is sitting around the fire singing campfire songs. Often that parent is the very last person in the world you would want to have access to this email. So my advice would be, if you feel like you need to air your frustrations about a parent or a student, which is totally understandable, do not do that in an email. The next area that we see costly mistakes in is failing to conduct effective IEP team meetings. This includes avoiding predetermination, like we discussed a minute ago. This includes careful documentation, like we discussed a minute ago. But it's also important to try to maintain general professionalism and civility, which can help prevent a number of conflicts from boiling over. So, simple courtesies like informing the parents how long the meeting is going to be scheduled for in advance, making sure they understand the acronyms and abbreviations that you're using. We have a lot of jargon in special education, and that can be sometimes somebody who doesn't do it all day, every day, doesn't always know, especially if it's a new parent to the special ed process. Making sure you're including the parent in the conversation, making sure there aren't sidebars, among the school members of the team that are excluding the parents and making them think that, there's some decision happening that they aren't a part of. Listening to them, including explanations for why you're including certain things or not including them, can all help ensure a professional meeting that not only can help keep conflicts at bay, but parents do sometimes record meetings and they don't tell you about it. And so if you wouldn't want the recording to be played in front of a hearing officer or a judge, it's probably best not to say it in an IEP team meeting. All right, next slide. So the final area where we see costly mistakes, and we alluded to this earlier, is in failing to ensure that your non-special education administrators, like your building principals, are aware of the special education rules. So when building principals, for instance, are not trained on special education regulations, we see errors in the disciplinary process. We see errors in processing disability discrimination complaints, like we talked about earlier. We see predetermination errors. So, a principal responding to a parent's request for speech therapy, for instance, and just saying, oh no, we don't do that at this school. That would create a compliance issue. So making sure that your non-special education administrators are getting good training, or encouraging them to attend, a training. We offer special ed trainings designed for principals, to give them the basics. That can really help avoid issues. All right, next slide. So in the last few slides, we've talked about areas where we typically see special education conflict, and hopefully gave you some pointers on how to avoid it. Now we're going to talk about what to do when conflict happens anyway, because it will. No one does everything perfectly all the time. Even if we did, we all probably can think of that parent in our district who is going to complain about it, even if we do it perfectly. So where do you turn when there's a conflict you can't resolve? There are a few options for getting legal support. Your county prosecutor may be able to provide some assistance to you, although education, especially special education, is highly specialized. So this is not a resource we see utilized often, but if you need help, it can be an option to check into. Your district, if you're very fortunate, you may be one of those districts who has an in-house counsel who you can call. That's a great resource. You can call us if we are your legal counsel, or whoever serves in that role for your district. You can also contact professional associations that you're a part of, like OSBA or BASA, who may be able to give you legal support. And if you're filing an insurance claim, like if you have a due process claim that's going to be very expensive, you may want to file an insurance claim. Then your insurance company can usually appoint counsel to help you. one thing I like to keep in mind before you pick up the phone and call a lawyer is that lawyers can sometimes create more conflict before they help resolve it. So I go to a lot of IEP meetings, and I can tell you I have not been asked to go to an IEP team meeting a single time because everything was going right. You know, you're not calling me because things are great. You're calling me because things have probably gotten into a bad place. And often the school districts we represent would like me to come in and just fix it and make it better and take the conflict away. But what I can tell you is that as a lawyer, I am trained to advocate within an adversarial system. So in other words, I do conflict. That's almost all I do, right? The presence of a lawyer often intimidates people. There are times where you absolutely need a lawyer, and a lawyer is the only way to bring something to a resolution. But just be aware that sometimes a lawyer can sort of up the stress and anxiety of the situation, and it can make things more contentious for a time at least, and not less. So while we're on the slide, I'll go back to what I was talking about a minute ago about using insurance when resolving legal disputes. So sometimes a school district may call us about a Department of Education complaint or a due process matter that we think is going to take a lot of time and effort to resolve. We will often tell you to contact your insurance to understand the scope of your coverage, not because we don't want to help you, but because sometimes that could be a more cost-effective way for you to handle the dispute. So when you call your insurance, you're first going to want to ask, is the type of matter I'm calling about covered? Because not all insurance policies cover all types of special education disputes. So that's the first question to ask. If it is covered, the next question you want to ask is, what is my deductible? So sometimes you may have, say, a $10,000 or $20,000 deductible that you would have to pay before insurance would kick in. And sometimes you may, in talking with your lawyer, decide, well, I actually think I can resolve this for less than that. And so it doesn't maybe make sense to file an insurance claim for this particular issue. The other thing to ask is who the insurance company would appoint to represent you if you did file a claim. So some carriers have really talented special ed lawyers who they could appoint. Sometimes it's an individual who has never had a special ed case before. They don't even dabble in it. So it's really helpful to know who would be appointed to decide whether it is worth, maybe it would be a lot less costly to use your insurance, but you might get a lawyer who is not experienced in those issues that could end up, getting you a worse resolution than you could get through a lawyer who has a lot of experience in that area. Another thing to consider is whether the insurance carrier will cover some or all of your own district counsel's fees. So a lot of times we will be involved sort of on the side. If the district has retained insurance and is using insurance counsel, we will still sort of be on call to help in the background. So sometimes your insurance will, in addition to providing you counsel through their insurance panel, will also pay some portion of your own attorney's fees. So it's good to know if that is available to you at the start. You'd also want to ask if there's a notification period in case you change your mind about keeping your own counsel involved. If things start to get expensive using your own counsel and you decide you want to use insurance counsel after all, you usually have to notify the insurance company within a certain period of time. So that is good to know at the outset too. Next slide. All right, so let's say you've decided you want to use a private attorney to handle a particular matter or to provide day-to-day advice for your school district. How do you select one? This is like buying a house. Most people aren't doing this all the time. None of us would ever buy a house without an inspection or a car without taking it for a test drive. So it's important also to do your due diligence when you're hiring a lawyer. In my opinion, the most important factor to consider is the experience of the legal team in the substantive area of the law that you are hiring a lawyer for. This is an especially critical thing in special education. I mentioned that we have a lot of people on our team. A lot of them are like, heck no, I don't touch special education. But then there are others of us who do it all day, every day. So in special education is an area that is ripe with potential pitfalls. So making sure that you have someone who's experienced in special education nuances is really important. Excuse me just a minute. I'm going to take out my AirPods because they're running out of battery and switch to the other speaker. Okay, can everybody hear me? Can someone leave a note in the chat and confirm that you can hear me?
We can hear you fine, Erin.
Okay, I'm getting affirmative feedback. Great. So we talked about experience being really important, especially experience in special education. And that impacts efficiency too, which is going to impact your costs. So if your attorney does not do a lot of special education work, they may not be able to efficiently answer your questions when you have them. If your attorney has to do a lot of research to answer a routine question, that's going to, of course, translate to higher fees for you. Not every question is routine. There are questions that we get that it's like, I don't know. We don't get that one a lot, and we do have to do some research. But ideally, because we have a fairly deep bench in special education, for instance, we can answer questions quickly. So that's important to evaluate when you are considering an attorney. Also consider the depth of the firm's bench. Are there others who can help out when your main attorney contact is sick or on vacation or in a presentation or in an IEP meeting or in court? If you're dealing with a solo practitioner, for instance, it can be harder to get answers to your questions. Also consider your lawyer's style. We discussed in earlier slides that lawyers can sometimes add to the tension of a situation. While that's true, some lawyers are more oriented toward practical solutions. Other lawyers are more pound the table type lawyers. Sometimes a pound the table type will seem satisfying in the moment, but if that lawyer ignores easy, practical, cheaper solutions because they are too wrapped up in the conflict, that can result in higher fees for you. We often say that the only people who benefit in litigation are lawyers. While you may feel you are 100% right in a particular special education conflict, and you want to take a due process hearing all the way to the mat, most people who go through that process are dissatisfied, even if they win, because of how time-consuming, expensive, and emotional it is. I personally have never had to testify in hearing or in court. I have questioned a lot of witnesses in court, but I've never been on the other side to be the person who's answering the question. But I have also talked to a lot of clients who have been on the other side of answering those questions. And even when they think they are 100% right, remember things with 100% accuracy, none of them enjoy being cross-examined. The other side is going to have a lawyer who's been specifically trained to get you to admit things you do not want to admit to, and that can be a really uncomfortable experience. So those are important things to consider. If you have a lawyer who is a pound the table type and is like, nope, we're taking this all the way no matter what, just keep in mind that there are downsides to going all the way through that litigation process as well. It's of course important to consider your lawyer's fees. Lawyers generally bill at an hourly rate, and they will bill you for any fraction of an hour that they spend answering your questions and IEP meetings, working on due process. Some lawyers may agree to a flat fee to provide legal services, within a certain scope. Obviously, you want to understand all of this up front and have an understanding of how much time you can expect the lawyer will spend on your representation. Next slide. Thank you, Kristen. So after you have selected your attorney, it's good to communicate your expectation for receiving legal services from that attorney. I want to know when I'm representing a new client, when is the best time for us to speak with each other? Do you prefer email communication or phone? Just as a caution, most attorneys find it very difficult to communicate by text. Number one, it can create confidentiality issues. And it's also really difficult to keep track of the information you share or the advice that we give by text messages, because it's not going to be automatically stored in the databases that we have for keeping track of those things. So I know myself and most of my colleagues strongly prefer that you email us to texting, but that is something obviously you can discuss with your particular lawyer. What about meetings and other consultations? Are you comfortable with the attorney attending remotely, or are most of your meetings in person? This can impact the attorney or firm that you hire. If you're in Cleveland, for instance, and your law firm does not have attorneys there, you are going to incur expenses related to travel time for me in Cincinnati to travel to Cleveland for all of your IEPT meetings, for instance. What about work product? Some of my clients ask me a question and they want a fully fledged memo with legal citations and statutory citations, the whole works. Others just want me to cut to the chase and sum it up in a couple of sentences. Others want me to call them and discuss it. So being clear about how you like to receive work product is important. Finally, who do you want your lawyer to communicate with? Some districts, I only communicate with the superintendent. Others, I communicate with the special ed director. So just be clear with your attorney about who has the authority to talk to the attorney and obtain legal advice on behalf of the district. So let's talk now about how to make the best use of legal counsel when you are in a conflict. And the most important piece of advice I can give you here is to remember that you can't put toothpaste back in the tube. Or to use another analogy, it's a lot easier for your lawyer to help you walk around a landmine than it is to put you back together after you've stepped on it. So when you come to a lawyer late in the game, it's often more difficult to come to a resolution other than just settling the case, writing a check, paying for things you may not have had to pay for had we focused more on prevention earlier on. So hindsight is 2020, and these things happen. But hopefully with today's presentation, we will have shown you some of the red flags that might be signaling it's a good time to involve a lawyer. If a parent threatens you with a legal claim or you get notice of a complaint or other type of legal claim, like a due process complaint or a lawsuit, at that point, you absolutely should involve your lawyer as soon as possible. When you make that call to your lawyer, it's important to be ready. So if you have ever had to call me or one of my colleagues about, oh, we got this OEC complaint or something like that, you know that we're going to ask you a million questions. We're going to want to know, how has the student progressed? Can you show me their progress reports? I want to know what their ETR says, what their IEP says. I want to know what the prior written notices say. Have we documented all the related service minutes we should have been providing? Because my colleagues' brains are immediately going to go to, what are the strengths of this case? What are the liabilities? Were there any procedural errors here? And that conversation is going to be a lot more meaningful if you have looked into the complaint yourself and thought about how to respond to the allegations as well. Also think about timeliness. Timelines often, and Claire alluded to this too, timelines often begin to run when a complaint is received by the school, and we see this all the time. The complaint is addressed to the superintendent. It sits on the superintendent's desk for a week, and you get it through inter-district mail several days later, and we only had 2 weeks to respond, and now a week and a half of that is gone. That is really going to impact the quality of our response to that complaint. So it's important to, again, flag for your administrators and superintendent's assistant, who is these complaints are usually addressed to the superintendent. Flag for their assistant, hey, when you see one of these come in, make sure I get it right away. Another phrase I like to use is garbage in, garbage out. So that means the advice I can give is only as good as the information I have. So for example, if I want to know what 50 plus 50 is, but I type into the calculator 49 plus 50, I'm not going to get the right answer. I put garbage into the calculator, and so I'm going to get garbage out. And it's the exact same with legal advice. When you call your lawyer, do not hold anything back. If you made a mistake, don't try to hide it. If we know about the mistake, we can help figure out the best way to deal with it. The vast majority of mistakes are not catastrophic. They can usually be fixed without major expense, but we have to know about it. And finally, remember that your attorney is there to give you advice, but sometimes it's going to be up to you as the school district to decide which advice you want to take. So there might be 2 or 3 options for resolving something. None of them are going to be perfect usually, and it's going to be up to you which of those roads you want to take. So one of the cardinal rules for lawyers is that the client gets to determine the goals of the representation. So you as the school district get to determine what outcome you are seeking. So your lawyer can advise you the various ways to get to that. But ultimately, it's going to be your choice, and the lawyer needs to respect that choice, even if they don't agree with it. All right, next slide. This is the section that I like to call Help Us Help You. So when you get that OEC complaint and you call your lawyer for help, here's how to avoid the garbage in, garbage out problem that we discussed on the last slide. So the first and best way you can help your lawyer is to provide organized records. So again, Claire talked about this. So when you get an OEC complaint, for instance, they're probably going to send you a list of like 12 or 15 types of documents they want from you. And my very favorite districts, and you know who you are, will do this. They will like create a folder for the first OEC request, which might be IEPs. So they'll label that folder IEPs, and they'll put all the students' IEPs in there in chronological order. And then maybe the next request is I want all the students' ETRs for the last, however many years. And they'll create another folder called ETRs, and they'll put all the ETRs in there in chronological order. That is a great way to help your lawyer get a jump start on responding to your complaint. So when we get all of the documents in a non-chronological PDF, or when you send your lawyer 50 emails with different attachments, that's fine, but it means that I'm going to have to spend time reading them, determining what's relevant, organizing them chronologically or some other way. And while we're absolutely happy to do that, it is going to mean more time that your lawyer spends and more fees for the district if you provide records in an unorganized way. The second thing that you can do is return your attorney's calls and emails. So often we are working for you on a very tight deadline. So the sooner we can get the information we need, the better arguments we can make on your behalf. The third thing you can do is to create a first draft of documents. So if you want to take a stab at drafting a response to an OEC complaint or drafting a prior written notice, for instance, then your attorney can go in and make whatever changes they feel are necessary. But if they're not starting from scratch, that can save you money. It can also make sure that all of the information you think is relevant is getting into the attorney's brain so that they can process it and craft the best response. The fourth thing you can do is almost always, we are going to have to do a search of your email server to get emails that are relevant to an OEC complaint or a due process complaint. So connecting us with your IT department can help ensure a seamless transition there. So following these help us help you rules will help minimize the amount of time your attorney has to spend on non-legal work, which is going to keep your attorney's fees as low as possible. Slide. Okay, so some other ways that you can help us or help your attorney help you. One is being open to your attorney's opinion. So as I said a couple slides ago, you're the client, you get to determine the goals of the representation. That is absolutely your right. But an attorney is more than just a hired gun, right? They can help you understand the risks and rewards of a potential course of action. And they are also on your side. They are there to help you and help the district resolve a conflict. So having a spirit of openness to that advice and assistance will go a long way. Be informed about the advice your attorney is providing. You'll be open to learning new ways of communicating with each other. At the end of a particular conflict, it can help to have a postmortem and discuss, all right, what went right, what went wrong? How would you, the client, like to receive information differently going forward? How would I, the lawyer, like to receive information differently going forward? That can help make sure the next time you're in a conflict with a parent that it goes a little bit more smoothly. Keep up with legal developments on your end, which is what you're doing right now by attending ESELA. So that's awesome. That's great because it means there's going to be fewer compliance errors for your attorney to get involved in the first place. And finally, remember that you are the consumer of legal services. So it's good to shop around. It's good to get second opinions. It's good to evaluate whether the legal services you have are working for you. If they aren't, you're allowed to share that with your attorney and you're allowed to go hire another attorney. That is absolutely your right as the consumer of the legal service. Next slide. Okay, so in these final few slides, we're going to talk about why special education disputes get so expensive. Before we get there, it's important to remember the various ways a district can be challenged formally. So Claire talked about a lot of these, and I talked about the other ones. Parents, the point of this slide is that parents have a lot of tools at their disposal to file complaints against the school district. And sometimes they will try multiple of these at once, which can get very expensive and frustrating. So we're going to talk about how and why legal fees build up in these kinds of challenges. Next slide. All right, so let's talk about the costs of special education disputes. So there are two components to the total cost. There's the cost of the result and the cost of the process. So if there's a settlement agreement, for instance, to send a student to a private residential school, that is the cost of the result. But you also have costs related to getting to that settlement. So you have your lawyer's fees to negotiate the settlement and draft the agreement, probably attend a mediation, etc. And a settlement is generally what we consider a good, or at least less expensive outcome. When we're talking about due process, not only are you going to have legal fees, but you're also looking at extra costs that are going to go to people who aren't your lawyer. And we'll talk about what those are in an upcoming slide. Okay, I'll start this slide with some lawyer jokes, some jokes at my expense. What do you call a busload of lawyers driving off a cliff? A good start. What do you have when 100 lawyers are buried up to their necks in sand? Not enough sand. All jokes aside, I'm sure all of you have had the experience of getting a bill from a lawyer and thinking, what on earth did they do to justify all of that money? I will share with you some of what takes up a lawyer's time here so that you can understand what your lawyer is doing when you get that big bill. So consultation, this is the time it takes to meet with you to figure out the facts of the case. No one knows the facts like you do because you lived it. So for you to kind of put that information in our brains is going to take time. This is the time we're going to spend talking with you about your legal options and strategy. Record review. So this is when you send us all of those documents that we have to look at to decide case strategy and to learn the facts of the case. That can take a lot of time. Very often there are thousands of pages of records in a student's education file, and reading and understanding and processing all of that can take time. On-site investigation and staff interviews. So sometimes we have to come to school and interview the staff that was involved in a particular complaint, or sometimes we'll do it by phone or over Zoom so that we can understand the facts and craft a strategy. Witness preparation. Like I mentioned earlier, if you're going to testify in a due process hearing, or if you're going to give testimony to an administrative body like the Department of Education, you want to be prepared for that. And so very often it will take twice as long as the actual interview or the actual testimony to prepare you for it in advance. Legal research. So my niece one time came up to me and said, since you're a lawyer, do you know all the laws? The answer is no. I do not know all the laws. I definitely do not know all of the ways in which those laws have been interpreted by the courts. So understanding all of that will help me determine what is the best way to argue this particular case. And doing that research and reading all of those court decisions does take a lot of time. Attending meetings, obviously, can take time. Resolution efforts, so attending mediation, preparing for the mediation, drafting motions, briefs, and other legal documents. So if you're going to due process, the lawyer is going to almost always have to draft documents as part of that legal case. Certainly, if you're going into court, that is going to happen. Presentation of the case at the hearing, so attending the due process hearing, that hopefully only takes a few days, but sometimes those can go on for weeks. So all of these things together are what takes up your lawyer's time and causes those big, scary bills that you get in the mail. All right, next slide. All right, so in the last slide, we talked about the various tasks that add up to create your lawyer's fees in a due process case. But due process cases also have costs. And this refers to the money that has to be paid to someone other than your lawyer. So these costs might include court reporter fees and transcripts. So a due process case is going to be recorded by a court reporter and transcribed into a written document that all of us can look at and cite to when we're writing those briefs. So witness A said this at 25 minutes into the due process hearing. We have to be able to cite to that directly to help the due process officer, or I'm sorry, the hearing officer know what we're talking about. Court reporters don't work for free. They don't transcribe things for free. So all of that can add up. You may want to have an expert witness if you're dealing with a particular disability and there's a dispute about what the child needs as a result of that disability. You're probably going to want to hire an expert to talk about it. So they don't work for free. We're going to have to pay them. Paying a hearing officer. Hearing officers don't work for free and you get to pay them. So how special for you? Parents' attorneys' fees, as Claire talked about earlier, there is a provision in the law that says if the parent is the prevailing party, you, the school district, have to pay their fees. And while there are some circumstances in which the parent can be required to pay your fees, that almost never happens. It's not automatic if you win the way it is for if the parents win. So that's something really important to keep in mind. There is the cost of implementing the judgment. So as we talked about, maybe that child gets sent to a residential school out of state. Maybe we have a big compensatory education award that will cost something. And then there are the costs involved in any appeal. So if we don't agree with the decision, or if the parents don't agree with the decision, there are going to be costs involved in bringing that appeal or defending that appeal. All right, in addition to the legal fees and costs that are going to third parties, there are also other costs to consider. First, there are administrative costs. So there are time costs involved in having some of your staff tied up in preparing for a due process hearing, testifying at a due process hearing, responding to the attorney's requests for information. That is time spent that they could be spent serving other students that they can't because they're working on this due process hearing. So that's a cost to factor in as well. Relationship costs. As Claire mentioned, the relationships we are dealing with here are long-term. This is not the kind of thing where the case ends and then everybody goes their separate ways. Sometimes you're dealing with a due process case for a student in the first grade, and that student is going to be with you for years. So you got to think about, okay, do I want to be in conflict with this family for 10 years or more? There's also the relationship to think about between the school district and the community, right? Do I want to have to defend the parent going to the press and talking about how terrible we are, even if we did everything right? If the parent goes and says those things, that can have a cost in the perception of the school district and the community. It can also have an impact on relationships within the school system. These can be contentious and can create conflict between administrators and their employees, for instance. So it's important to think about too. And then there are the costs of potentially setting a precedent. So if we settle a case and other parents hear about it, do they think, well, I'm going to bring a legal claim too, because the school district will probably settle it and I'll get what I want. Or, if we go all the way to a judgment and the parents win, are there costs associated with that of other parents thinking, great, well, I could bring my case and win. So those are things that you have to think about when deciding whether to settle a case or take it all the way to a hearing. Next slide. Okay, so we've talked all along today about how to hopefully prevent conflict, but as we've said, it's not possible to prevent it in all circumstances. No one does everything right all the time, and even if you did, there's going to be a parent who just is never going to be happy with what you do. So there's no way to prevent it, but hopefully we can reduce it. We do that by educating ourselves on compliance and on how to dial back the temperature of situations, which we've talked about today, how to detect early warning signs. So those top 10 special ed conflicts that we see, if you start seeing one of those develop, if you start seeing a parent emailing the principal, emailing the superintendent, emailing the board, these are signs that the temperature is getting hot, and you may want to get your lawyer involved. And it's usually better if you can to address and resolve those as soon as possible before they blow up into a complaint to the Department of Education or a due process complaint. So some things to keep in mind is that when you are dealing with conflicts, if a parent is going to file some kind of public complaint, you're going to be working with your district leadership, or maybe you are your district leadership. So knowing your superintendent, knowing when, it says whether and when. I would think that generally speaking, if a lawyer is involved, your superintendent should know about it, but knowing how your superintendent likes to be communicated with, and how much and how they like to receive information is important. knowing your board, knowing is your board going to be open to, generally speaking, a board has to approve a settlement, for instance. What kind of settlements is your board going to approve? What can we commit to? Making sure that your board knows that they do have confidentiality obligations to students. So if they are getting questions from the press, understanding what they can and can't say. And then knowing your press. Some communities have a very active press that is coming to all the board meetings and is going to report on what gets talked about. Very often the best comment is no comment, but certainly before you speak to the press about an issue, it's important to probably talk to your district's council, but certainly understand from your superintendent and your board what they want you to say. Okay, so that wraps up the substantive portions of our conversation today, but I do, of course, have Laura's poem to share with you. And this one is one of my favorites because it's from the perspective of a special education lawyer. So this is, I cannot go to school today, the special ed lawyer version with apologies to Shel Silverstein. I cannot go to school today, said school attorney Jill McVeigh. I've got 4 contentious IEPs and state monitoring. Lord help me, please. My plate is full, my nerves are frayed. I think I need my own one-to-one aid. I might also add that to my sorrow, I cannot go to work tomorrow. I have the chills, I'm feeling faint. That angry parent filed her 6th complaint. Work on Wednesday, I just won't go. I can't handle another masked TRO. Return on Thursday, no, that won't work. I can't meet with that advocate who drives me berserk. Then there's Friday, and if I'm still ill, you handle that private school tuition bill. Be back next week, can't give you a promise that I won't be hiding on a beach in St. Thomas. You go to the board meeting, attend in my place, update them on their federal court case, explain OCR's finding of disproportionality and the nuances of medical THC. Help them navigate that bullying hotline and all of the discipline implications of Title IX. Clarify special ed funding and the importance of RTI. And once the school year ends, I might come back in July. Okay, all credit to Laura Anthony. That was fun. Okay, so we are just about out of time, but I do have a few minutes for questions if anyone has any. All right, here is a question. Can you clarify what other communication documents other than work emails are public record? Teams messages, private texts that mention the student, etc. I'm always trying to impress upon my fellow staff members how careful they need to be. Yeah, I mean, the safest thing is to assume that pretty much anything, any document at work certainly is potentially a public record and a student educational record. Your team's messages about a student, about work, absolutely are public record. Your private text messages that talk about a student, probably also public record. So it's important to keep that in mind and be really careful about how you communicate. The best plan is to assume that if you're talking about work or if you're talking about a student, it is probably public record or a student educational record that can be made public. Any other questions? Okay, question from the inside. Kristen has said, we've had cases where I guess this is the comment on the last question. We've had cases where private Facebook account messages of a teacher were records because they were discussing the education of the child with the child's parent. That is true. That is true. Any other questions? Okay, I am not seeing any. So I think we can probably end today's session, but if any questions come up after today, you can feel free to contact me. My information is there on the slide, or Claire, her information is there as well. And I appreciate all of you attending today. Thank you.